This conference will now be recorded.
Hello everybody, this is the Advocate Me team. My name is Sandy Barrett and we have here Serenatopia and Melissa Bruce, and we're the team that is handling the class action with regards to the unlawfulness of the states and territories' vaccine mandates that are currently affecting us around the country. What we're hoping to achieve from this short video is to provide a good outline of our strategy for this action and in effect show you who this is specifically affecting, why we're even doing this, what you can expect to get out of this action, and what this action is not about as well. Just some clarity around that. But first, we should give some pretext to this. What this is actually about is challenging the unlawfulness of these mandates for the flu vaccine specifically. And the reason for this is that the flu vaccine is not the subject of the gold standard testing for safety and efficacy like all other drugs are. There are examples, and even recent examples right here in Australia, where it has been a cause for some very serious side effects, including serious long-term brain damage. The directives are creating big problems where people are unable to visit their loved ones, and residential aged care facilities are preventing that from happening. People are losing their jobs, and people are receiving the flu vaccine against their will in order to see their loved ones and to keep their jobs. And some people are even being injured in the process of having those shots. So while there are exemptions like anaphylactic reaction and Guillain-Barré syndrome, for example, there are no precautionary screen tests to see if you're likely to have this type of reaction. And we see this as a bit of a problem. Now, what we've done is we have written to politicians. We have sought to find out what the science is that they've relied upon to make these directives in the first place. We have collated several people's stories who've been damaged by these directives and presented their cases to our politicians to show the need for change. We have demonstrated to politicians where there is clearly confusion about what the laws are. And we've even helped with lodging complaints with the Human Rights Commission. And even they seem to be quite confused about these directives. So we have really done our best to try every possible avenue that we believe is available to us, and nothing has worked so far. So we're left with no other option really but to have the courts decide. And that is really what this whole thing is about. So Serene, if you want to just have a bit of a chat now about what the strategy entails.
Thank you, Sandy. Thank you so much, Sandy and Melissa. Just as by way of background, as I started this inquiry for myself in terms of clients coming to me who have been affected by the aged care directives issued by the states and territories, in making this inquiry with them, I met Sandy and Melissa, who now joined with my team to try and create and affect this change. Now, who does this class action impact? Firstly, just by way of very simply, my name is Serenatopia. My practice is called Advocate Me, and my expertise is in human rights, in administrative law, and I'm extremely interested in regards to these matters to try and look at affecting change. I do feel that these issues with these aged care directives signal other problems that might be coming ahead, and I do believe it's important for us to start creating precedents around this. So who does this class action impact, and who are we inviting to come forward? Firstly, we're inviting obviously people who've been directly affected by the aged care directives, and these are visitors to aged care facilities who have been either denied access or had their access regulated or interfered with. And they are in all states and territories. So we're inviting people from all states and territories. also employees who have been affected by these aged care directives, whether directly from the aged care facility itself or indirectly through other facilities, like, for example, paramedics who have been told that because they do visit aged care facilities by their employer, that they will also be required pursuant to these aged care facility directives. So these are the people that we're actually calling out for this class action. We have already a lot of people who've joined, but we're obviously also wanting to ensure that we've widely put the net out to catch anyone who is impacted. We've had a number of people who've shown interest, but who have not been directly impacted by the aged care directive. So it could be other employers who are introducing these mandates through policy rather than through the aged care directive. So whilst we welcome having an understanding of that and having you express an interest, but ultimately that will not carry forward for the purposes of the class action. We've also had students who've been impacted by universities saying that the directives somehow impact them when they don't. But also we welcome hearing from these people, but for the purposes of our class action and the participation, it will be in relation to the aged care directives themselves. Now, there's been some confusion with regards to who is actually making these aged care directives. Is it the Commonwealth or is it the states and the territories? And what we say here is that the Commonwealth, through Scott Morrison's cabinet and through an advisory committee from the Commonwealth Department of Health, they have created a recommendation that was presented formally through a press release on the 21st of April, and that invited the states and the territories to then, under their respective public health acts, put out these directives in relation to these recommendations that were made by the Commonwealth. In terms of our legal strategy and what we're doing, the laws in Australia are very complex, and they don't provide a lot of very clear methodology in which to pursue these issues and seek to have these types of directives declared unlawful. There is one particular strategy called judicial review, or where you seek to have a review of a decision maker or a directive or a determination that was made by a decision maker. And what's happened here is that when the Commonwealth recommended this, the various states and territories, through either their chief medical officers, and in some states it's the police officers, the chief police. In other states it's been the members of the government who have put this out through their directives. So what we're doing here is the process of judicial review, where we're seeking to say that, or seeking the court to declare that these directives are unlawful, and a prohibition order, what is called a prohibition order, to say that they should not be issued in the same manner again. And the reasons that we're saying this is a number of reasons. The first reason is the evidence that was presented to justify these directives are completely inconsistent. The evidence mainly has focused on the idea that if you take the influenza vaccine, you will have reduced hospitalizations. And we do say that in this regard, the aged care directives do not apply to hospitals, but rather apply to aged care facilities. So there's inconsistencies here, and Melissa will speak briefly shortly with regards to the evidence base. We also say that there are inconsistencies between the way that the states and territories have applied these recommendations versus what is actually allowed to happen on the Commonwealth level. And there is a legislation on the Commonwealth level called the Biosecurity Act. And the Biosecurity Act talks about when you have a state of emergency and when you declare states of emergencies. And we say that the declaration order that was made on the Commonwealth level by the Governor-General restricts how medication, bodily searches, testing, medical examinations, all these processes which interfere with the right of self-determination of an individual have certain processes. So you can't just go and oblige a group of people to do something without actually assessing their individual risks. And you have to assess the individual infectious risk of a particular individual before you issue them any kind of individualized orders requesting them to be vaccinated, searched, tested, all these requirements that are there as a protective measure for the right of our self-determination. So we say that they're inconsistent as well. We also say that relevant factors have not been taken into account or consideration, and Sandy mentioned issues around safety and efficacy. We have the Cochrane Review, which very clearly states that the influenza vaccine has very, very minimal efficacy. So if it has minimal efficacy, why then oblige it on individual and request or necessitate it on individuals or a group of people as what has happened? So there are a number of reasons why we're challenging this, and the right process I think we have, as we said, very limited under the law, is the judicial review. Unfortunately, one aspect of the judicial review is compensation. That if you are seeking a judicial review, you usually are curbed by what you can request from the state and government, and that is a protective measure that is put by the legislator so that it doesn't open up the floodgates of compensation. But I think what we're motivated by here collectively as a group of people is to say, well, no, to our governments and to our administrators, to say, no, you've gone beyond that power and we're more interested in stopping you from doing this than really seeking compensation. And in this circumstance, and in this particular action, we might be curbed from actually going after compensation. However, that does not stop that once we do get a result, that each individual, I would assess their circumstance and look at how we can restore some sort of justice individually for each person. But in terms of this class action, the process will be a judicial review where the right of compensation is curbed. We've had some other questions as well with regards to what happens if these directives lapse or are revoked, which is what the current legislator has stated, that that these directives will not last past the state of emergency. And we say that that doesn't impact our class action, because what we're seeking here is the reason why the decision maker made these decisions and these directives is unlawful in the first place. And we're seeking to obviously create a precedent to deter our states and territories, and also some of the Commonwealth administrators and the executive from making these types of decisions without looking at the evidence and without actually appropriately looking at the laws and what they say. Another element and another question we've had that has been quite consistent is the question of costs. Now, we're putting obviously this video out to try and invite people to express their interest, and we believe that the more that there are part of this process, that the costs will be most certainly mitigated. And if we can aim for a target of 200 people as part of this class action, then the costs would be extremely minimal, and they will be restricted to 2,000 per family, which means that if you and your partner and your other family members are impacted by not visiting an elderly parent, then all of you would only have that one cost assigned to yourself. We're also considering the scenario of pensioners, because we know a lot of pensioners are being impacted by these decisions, and we're also looking at significantly discounting the participation for pensioners, and in some circumstances not requesting any funds from them. But again, we will explore that once you express your interest in moving forward. And lastly, some of the issues that we've had as well is that what if the government changes its laws and allows the mandating of vaccines full stop? I do think that is going to be a very difficult exercise for the government to do, because there are rules in relation to self-determination. There are human rights in this country, and I think our Commonwealth government knows this very clearly, and that is why they're trying to sneak these directives in to really test out and experiment, I believe, with the Australian public and citizens to see how far they can be pushed. I don't think it's going to be an easy exercise for them to change the laws, because they were specifically designed to cater and factor for issues of self-determination. And I'll put you on to now, Melissa.
Oh, wonderful. Thank you. Thank you, Serene. So what I wanted to talk about just really quickly today is my involvement in this class action. So I have been doing a lot of work in relation to research. When the wheels started to fall off the world, I started writing freedom of information requests, compelling various governmental agencies to provide me with specific documents and information in relation to these directives. As the powers that were used to make these directives in each state and territory, they stem from a state of emergency surrounding COVID-19, not influenza. So they had to actually link the mandating of the flu shot somehow to COVID-19. The way they did this was by saying that the flu season would fill up the hospitals, and not only that, but if someone caught COVID-19 and the flu simultaneously, it would be especially dangerous and flood the hospitals, etc. So I put forward these requests asking the Federal Health Department for the documents and information that their committee, called the Australian Health Protection Principal Committee, relied on when making the advice, which was followed to issue these problematic directives. Now, the documents I asked for were to show the following: an overall reduction in hospitalisation post-flu shot, an increase of hospitalisation should someone catch COVID-19 and influenza. I asked for documents showing an increase of hospitalisation should someone catch influenza and a coronavirus. I asked them for the risk assessments that were carried out prior to issuing this advice, and I also asked them just simply for all safety and efficacy studies for the current flu vaccines that are approved for administration by the Therapeutic Goods Association that they relied on. I have had response after response after response from the Federal Health Department stating one thing: the documents and information I asked for don't exist. It would appear that these directives were pulled out of a hat, and they hoped really that the propaganda would do the rest. Considering how few legal professionals have been jumping up and down to issue a challenge to this, I guess I can see how they thought they'd get away with it. However, obviously that's not the case, Serene.
Thank you so much. Thank you, Melissa. I appreciate that. And I think, I think that number one reason that is motivating me to do this is because I feel that making these decisions and taking these directives without an appropriate evidence base and without defining the reasons and without clearly articulating why these things should happen is an extremely dangerous platform. And as a result, and as Sandy rightly said, people are getting damaged, people are getting hurt. There are adverse reactions that are being ignored to the influenza vaccine. And if there's more and more people that are being obliged or necessitated under false pretenses, in my opinion, then, we're going to have some serious ramifications to deal with. And I do believe that it is important to keep our administrators clean. And that's why I'm very motivated to continue with this class action. Thank you.
Thanks, Serene. Thanks, Melissa. I guess for those of you who resonate with the message and the strategy that has been offered up and would like to participate in this class action, I direct you to our website, which is simply www.advocateme.com.au. And there's a class action button at the top. If you just click on there, there's a short video to watch and a link that you can click on to submit your details, and we will get in touch with you as soon as we receive your information, and we hope to hear from you soon. Thank you guys for your time.
Thank you. Bye.
Bye.